To Senator Madigan.
Thank you, Chair. Thank you for your attendance. The CER's power to accredit is set out in Regulation 4 of the Renewable Energy Electricity Regulations 2001, eligibility for accreditation. Paragraph 14.2b of the Act states the power station must be operated in accordance with any relevant Commonwealth, state, territory or local government planning and approval requirements. Before the CER can decide whether a power station is eligible, it must first determine what the power station is, and accordingly Section D of the application for accreditation requires applicants to specify the components of the electricity generation system that you consider to be a single power station. The applicants on behalf of the Waubra wind farm define the power station as comprising of 128 wind turbine generators, 5 collector substations, the list goes on. The Clean Energy Regulator accredited the Waubra wind farm on the 10th of March 2009. Just after the first turbine started operating, but 4 months before the facility was constructed and fully operational. How did the Clean Energy Regulator come to form the view that the Waubra wind farm was eligible for accreditation whilst it was still a construction site and not the complete single power station described in Section D of the application?
Well, thank you for that question, Senator. And before I proceed to answer it, at least in part, I would like to acknowledge that there is now a Senate committee, which you're on, which is the Select Committee on Wind Turbines, which is scheduled to report in June 2015. We're just finalising our submission to that committee, which will go to amongst other things, our procedures for accreditation and also for suspension, which you've asked us about on previous occasions. And I look forward to having the opportunity to appear before that committee, and we can discuss some of those matters there, which I think will be helpful. I'd also note that we've answered in excess of 40 questions on notice regarding these matters, we always attempt to answer those questions as fully as we can and in the context of what the law provides for and our interpretation of that law. So going to that question of the accreditation process, it is right that the legislation was designed to enable a power station to be accredited at the point at which it began generating electricity, even though the commissioning of that is sequential. So the issue that we are observing is whether that power station has met the requirements of the planning requirements, which are essentially to have the appropriate approvals in place. And that's the basis on which we determine that the power station is being operated in accordance with the requirements at the time. And I'd draw a distinction between that and the provisions that are made on which we have powers under certain circumstances to suspend accreditation. I'm not sure if I can expand any more on that, but I'll perhaps just turn to Mr. Williamson, who has line accountability for this, to see if he can enlighten you further on that process by which we determine what the power station is, and then accreditation happens, as I say, at the point at which it begins generating electricity, and it is metered, which is one of the other requirements, but as you observe, isn't necessarily fully completed at the time.
Mark Williamson, Executive General Manager. As Ms Munro has stated, Senator, it's our view of the law that the accreditation decision can be made around the time of first generation, and as you've outlined, Senator, it can sometimes be for a wind farm around about 12 months from the first commissioning and generation till final commissioning. Our interpretation of Regulation 4 is that, as Ms Munro says, that we need to make sure they've got all necessary approvals in place, and that it would appear that those approvals can be complied with. But it's not uncommon for the concerns that have been raised about wind farms, for those to not necessarily emerge until after full commissioning.
See, what I'm trying to understand here is that I believe that the application for accreditation was received by the CER on the 14th of January 2009. And there was a photo attached showing a substation, 10 turbines and a further 5 sites at various stages of construction. So you had 10 wind turbines standing up. You had another 5 sites at various stages of construction. You had 1 substation, but in the application for accreditation, it spoke about 128 turbines, 5 substations, a switching station, and you've accredited something that, you know, is like 12% roughly built. Like, you know, you've accredited something that's not even 1/8 of the way there.
Senator, it's our view that we get one chance to accredit and that they can in fact put forward all the components that are intended, and that the accreditation is intended to happen around the first point of generation. Certainly understand what you're suggesting, and as Ms Munro says, I think these matters might be best explored in the Senate Select Committee as to whether or not the law could be improved.
Right. So if the power station didn't exist at the time it was accredited, how did the CER satisfy itself it might be operated in accordance with any relevant Commonwealth, state, territory or local government planning and approval requirements?
Senator, if I can just intervene on this, and then perhaps Mr Williamson will go to the process. The power station did exist. The accreditation provides for the accreditation of the whole power station, and the way power stations of that nature are designed is that they all of those elements, although they're built sequentially and they're commissioned sequentially, do combine to create the power station. And in particular, they are, you know, those components are metered as one. So there's one power station that will eventually be fully operational and will generate electricity which is metered at one point. So that's the background to why there is a single point of accreditation. I can only reiterate that we, right from in our predecessor organisation, the Office of the Renewable Energy Regulator, so right from the start of the way that the introduction of the legislation, the way that it's been operated, is to allow that accreditation to happen at the point at which the power station starts to generate electricity. And that is the point where it is actually operating as a power station. It is, you're absolutely correct, it's not necessarily the full power station, and this is an issue that clearly has also come up again in the context of Gull and Range. But nevertheless, it is operating as a power station. It has all the consents for that full scope of the power station as defined. The components, all of those components are covered by the appropriate consents, and therefore they are in compliance with the requirements to have those consents in order to, if you like, continue with the construction. So that is the point at which accreditation occurs, and that is so to enable the power station to be able to claim renewable energy certificates for the electricity that it is now generating, even though, of course, it's only from a part of what will ultimately, and that's a very normal way, not just for power stations, but for many other major facilities to proceed, that they're only commissioned sequentially over a period of time.
Senator, I think Ms Munro's outlined that fairly thoroughly. We do a thorough look at all the approvals. We stay in touch with the state and territories to understand the full suite, and we make sure that the approvals that the company has are for the full scope of the proposed power stations to be accredited. We also look at whether there's any available information that suggests that anyone is suggesting that there is any non-compliance before we make that decision. But you're probably aware that even if we did wait to the point you suggested, these things in terms of planning conditions, there are not normally compliance statements issued by the various state and territory regulators anyway.
The Waubra Wind Farm's conditionally issued planning permission included the post-construction approval requirement of noise compliance. Of course, compliance with this approval requirement could not be determined by the state authority until the 128 turbine power station was complete and operating. Doesn't this too suggest that the CER credited Waubra Wind Farm without appropriate regard to the satisfaction of Regulation 4 that the power station must be operated in accordance with any relevant Commonwealth, state, territory or local government planning and approval requirements?
Senator, I can only reiterate what I've already said, that our reading of operating approval with the relevant requirements is that they have the relevant consents at the time which they construct the power stations, which indeed they had. And it's also the case, specifically with respect to Waubra, that at the time of the accreditation there was no suggestion that they were not operating in compliance. And I can certainly turn to my General Counsel perhaps to explain the niceties, if you like, of that interpretation more carefully. So perhaps I'll do that. Yeah.
So, thank you, Ms Munro. Jeff Purvis-Smith, General Counsel. There's two things that we look at in order to do that assessment. As been explained, whether the necessary approvals are in place, and then we look for any reason which would suggest they cannot operate in accordance with those approvals. We can't crystal ball as to whether they will always comply. That's an impossible task. But we can look to see whether there is any clear reason why they could not, based on the information we have at that time, meet those approvals.
Okay. The CER's accreditation explanatory notes instruct applicants to provide evidence of all approvals and conditions of approval and submit them with their application for accreditation. In addition to Regulation 4, the Act reinforces in 13.2a, the application must be made in a form and manner required by the regulator, and again in 14.2b, a power station is eligible for accreditation if the power station satisfies any prescribed requirements. It is clear that the test for eligibility is to be determined as a matter of present fact. Where does the legislation give the CER the discretion to disregard any prescribed requirements? And where is the CER given authority to accredit a power station before its eligibility can be proven or properly determined?
Senator, I think we find once again that you are placing construction on the wording of the legislation that we do not. And we certainly would not accept the assertions that you make in that question that we are disregarding or setting aside the requirements of the law. In fact, quite the contrary. We exist only to administer the law. Our decisions are reviewable and subject to review in the courts, and so we take very seriously the requirements to apply the law, if I might say, without fear or favour. So I'm not sure how well we will be able to answer that question, given that it's based on a premise which we don't actually agree with. However, again, I'll turn to Mr. Purvis. Mr. Williamson, I think, feels he can elucidate that, so we'll have a go at it.
Thanks, Senator. We've again contacted the relevant Victorian Planning Department very recently, who have still stated that neither they nor their minister have reached a landing. On whether or not Waubra is compliant. So the logical extension of what you're suggesting is if we waited to make an accreditation decision until there was an absolute roll gold view from the state regulator that it was compliant, we still wouldn't have Waubra accredited today, and we would have clearly appeals on foot well before now. So I think that kind of illustrates that we simply have to make the decision at the time of the accreditation, as we believe the Act requires, with the best information. We can't simply hold it in abeyance for years until there's some emphatic opinion on compliance from a from a state regulator.
Just one question? Okay, thanks.
Will the CER conduct an audit of all LRET power stations to satisfy itself that no other accreditations were possibly granted prematurely, and shouldn't any power stations discovered to have been accredited before completion and or without submitting to the CER evidence of all required approvals be suspended until eligibility can properly be determined? My point is that from what you've just told me to the previous question, you've said to me that you still haven't got anything that just comes out and says from the state government that it is compliant. Is that right? Yes.
I think more to the point is it has not been established that it is not compliant. So I think, Senator, well, you are asking us to apply tests which cannot in fact be applied, and as I've discussed this with my colleagues, I mean, this has really becomes quite an important philosophical point, which is about, you know, what can be proved and what cannot. So in this case, clearly we would be able to establish or more likely rely on the relevant regulator having established that non-compliance occurred. And that is a test that we certainly do apply and consider carefully. We don't necessarily have to rely on the findings of a court of law. There might be other evidence which established non-compliance that was sufficiently robust that we could find that on reasonable grounds. However, the test of is it continuing compliant is not something that can be applied, I think, in the sense that you would wish. So to your question about the audit, each, again, I think it's based on an approach that, on a foundation with which we don't agree, but just to go back, each power station is accredited through a process which Mr Williamson has outlined, and we do undertake that process at the point at which the power station applies, which is generally at the point at which it starts to generate electricity. It is then a functioning power station. It's not necessarily fully built, and there certainly are power stations which were not fully built, and as I mentioned, Golden Range is obviously one which is currently under investigation for that very reason. Nevertheless, that does not. We don't infer from that those power stations were accredited prematurely, which I think was the thrust of that question. They were accredited properly, with proper scrutiny, that they had the correct approvals at the time, that the power station is operating, the part of the power station that is built and functioning is operating according to requirements, which include things like metering requirements and so forth. So that is all done at the time and has been done for every power station that we've accredited. So I don't think there is any value to us reviewing all of those, because we have been consistent in the way that we've applied those processes. Now the question, the later question, which is, having been accredited, do circumstances change in the course of the further construction of the power station, is certainly a reasonable question to ask, and it's not one that can be addressed through the accreditation provisions. It could be addressed through the suspension provisions, and we've had some separate discussions around that. And as I say, these are matters which we will air further in the submission that we're going to make shortly to the Senate inquiry on that matter, so certainly happy to resume that conversation in that setting.
Mr Williamson, does the CER have a definitive statement from the Victorian Minister for Planning of compliance or non-compliance of the Waubra wind farm? Yes or no?
There is no definitive statement from the Victorian government. So there's no definitive
statement, so in effect it's in the demilitarised zone of no man's land. It's either non-compliant or compliant. Is that what you're telling me? You've got no definitive statement from the Minister?
They have still not made a definitive statement, Senator, that's correct.
6 years on.
Thank
you, Chair.
Senator Maddox.